All rise. The Court of Appeals Division 1 is now in session.
Thank you. Be seated. Good morning. We are here for argument in CV 22-0286, Hanzuk versus Hanzuk. Am I close? Okay. As you probably know, we record and are currently live streaming these arguments. So when you stand up, please announce your name and the name of the person that you represent. You each have a maximum of 20 minutes. You're not required to use all of that time, but you are welcome to do so, and you keep track of that time on the podium. If you'd like to save time for rebuttal, that is for you to do. Now, keep in mind, we've read the briefing, studied the record, discussed the case in conference this morning, and with that, you may proceed.
May it please the court, my name is Stanley David Murray, and I'm the attorney for the appellant Julianne Hanzuk, who was the respondent in the lower court proceedings. And I would like to reserve some of my time for rebuttal, if I may. When we went before the trial court, we presented a rather simple and straightforward case. The parties owned 4 frozen embryos from prior IVF procedures at the time of the divorce. The divorce decree didn't provide for distribution of the embryos. And so we have an unallocated asset. We're asking the court to distribute the asset, but not pursuant to ARS 25-318D, but instead under the new statute recently enacted that requires the frozen embryos be distributed to the party who wants to bring them to birth. And so under that new statute, ARS 25-318.03, we were requesting that the embryos be distributed to us. Unfortunately, the trial court misinterpreted, in our opinion, ARS 25-318.03, and I apologize for keep running these numbers off, but we got to go back and forth between the statutes, because she interpreted it to mean that it only applied to proceedings under 25-318A.
Counsel, before you get too far down the road with the statutory interpretation, let's back up.
Yes, sir.
To truck a little bit. Explain to me why, or to the court, what is the significance of your arguments regarding that the court erred in, I'm going to call it the June 2014 ruling, the minute entry, which essentially Judge Hicks, I'll just call it Judge Hicks ruling. What is the legal significance of your argument? How does that matter if seems like your ultimate destination is invocation of the new statute? So help me understand your concern or your argument as to why the court erred in incorporating Judge Hicks' ruling into the consent decree.
Well, Judge Hicks' ruling wasn't a final order. It wasn't signed. It wasn't dated. It wasn't entered as
understood, but didn't the parties agree? Didn't Judge Hicks direct the parties to incorporate both parties?
Exactly.
To incorporate it?
And that means it was an error by one of the parties, or both parties, rather than by the judge. So it doesn't come under the Rule 85A clerical error, because the court didn't make the
Assuming
mistake.
you're right, why does that matter for your ultimate argument?
Because it allows me to say we have an unallocated asset. And actually, if you look at the order itself, it didn't distribute the embryos. It said the embryos
it seems like you just answered my question. You're saying even with the amendment, it still didn't. Isn't that your argument? Even as amended, even if the court correctly, which I tend to disagree with your argument that it needs to come from the court as opposed to the parties. I don't think the rule specifically addresses that. But regardless, your position is it was unallocated regardless of whether it was in the Judge Hicks ruling or whether it was ultimately incorporated into the consent decree. Aren't you arguing it still wasn't allocated?
Yes, sir. Because my first argument was that under the Valley Bank case, which I cited in our brief, it talks about the error has to be committed by the court. So assuming that argument isn't going to be accepted, my fallback argument is, well, we never did get the order distributing the embryos because the order says they're going to be held in storage until the parties can agree. And
what is your authority that your client was entitled to have a distribution? Wasn't your client entitled to be heard on the matter? And Judge Hicks issued a ruling arguably in accordance with then current law, citing the Tennessee case. There wasn't a whole lot out there for Judge Hicks to rely on, and said essentially, look, I'm going to do essentially what this contract type analysis, and that means you have to agree down the road. I mean, you have to agree. There has to be an agreement. Otherwise, it's going to be in limbo.
And I think
and that's a final ruling. That's a final ruling. Was not challenged by your client. So, what are your best arguments for why that needed to be reopened?
Because under ARS 25-318, the court is required, shall distribute community property. And that didn't happen here. When you say
It's property? I thought
well,
Judge
it's
Hicks said
special
it.
property, I guess. I don't know how to clarify or classify embryos. Under the Jeter case, it's not a person. And at the same time, it's not personal property, it's special
I mean,
property.
just plain language of the statute says property, and it says nothing else.
Well, under the Rooks case, I believe it is, they qualified it as special property. And so I guess it's a hybrid of property in that regard. But my point is that Judge Hicks did not distribute the assets. And so that's why we feel it's an unallocated asset that needs to be divided now. And since we're dividing it now, the new statute would apply.
Let's take this out of the maybe domestic relations matter for just argument's sake, and say this is just a breach of contract case where one believes that the law was maybe was undiscovered, something should have been brought up, arguments the court arguably just completely erred. I mean, it's 7 years later, and you're looking back. In anybody's mind, do you get Rule 60 relief to reopen the court's judgment in a regular civil case?
Well, that's our argument under 85 B5, I believe it is. Prospective application is not equitable. The parties are in a stalemate. They're never going to agree on distribution. And so now that we have this new statute, that change in law would affect
And you're saying
substantially.
that change law would apply to every situation in Arizona where this same example exists?
Where a new law takes effect, yes, sir, I believe so. If it wasn't distributed,
But
it
what
would
about
agree.
what about the case law that from our Supreme Court and this court that suggests that you don't apply a statute retroactively to events that have already occurred?
We're not applying it retroactively.
You're not applying it to any events that have already occurred?
No, sir, I'm applying it to the situation now where we need to distribute the unallocated asset.
What is
Again,
the event that the statute applies to?
that my client wishes to bring the children or the embryos to birth. Because it wasn't distributed before, now we need to distribute it. What statute covers that? 318.03 now specifically provides that
So the event is not the dissolution that requires,
No, ma'am, because again, the dissolution decree didn't cover this issue, didn't cover this property.
If I agree with you on the dissolution degree, but still think that the minute entry means something, didn't it allocate it to both of them? I mean, it seemed like it said, this is something you guys, is both of yours, both your responsibility, and you guys got to work it out. Isn't that an allocation?
Well, they already owned it as community property, and because they're being divorced now, 25.318 requires the court shall divide community property amongst the parties.
But it can assign real property to the parties as tenants in common. I mean, it could do things that aren't necessarily you get this and you get that. It could say you guys jointly own something now, and that's the allocation that I'm making.
Well, that's when we mentioned those cases. I believe it was the case out of Wisconsin or Iowa that had the contemporaneous agreement approach.
All those things kind of blur together for me too. So.
Well, that's the problem with these agreements on the frozen embryos, specifically dealing with frozen embryos. You're never going to get an agreement. You've got a lot of emotional issues going back and forth. So the contemporaneous agreement approach should not have been used in this case. Again, now that we have this new statute, we want the new statute applied rather than the other common law remedies.
But shouldn't that have been challenged 7 years ago? It's an unchallenged ruling of the court. It could have been challenged by special action. It could have, counsel at the time could have insisted that not become part of the consent decree, but it be put in a separate with, what is it, 78, it's not the right rules anymore, 54.
Correct.
That's 54B language in there or something. I mean,
Right.
but no action was taken. So how does that, with those factors, how do you get over the threshold to show that these are extraordinary circumstances, that it would be inequitable to allow this to sit when your client, so to speak, slept on her rights?
Well, the trial court in the recent ruling didn't say that we were guilty of laches or guilty of not appealing or special actioning the decision way back when. Instead, the court said that the statute 25-3-1803 does not apply because of its interpretation. So I think the relevant inquiry here is what the trial court did and whether it was correct in interpreting the statute. I suppose my client should have probably appealed that ruling, but at that time, everybody was waiting for the decree to be entered, and the decree didn't have that language.
Because Rule 85 speaks in terms also that it needs, under subsection 6, I think, it needs to be brought in a reasonable time. I mean, even after the statute was adopted in 2018, here it was 3 years later before your client took action. How is that a reasonable time under Rule 85?
Well, I can't say it's a reasonable time or not because it depends on the circumstances.
I mean, but the clock's ticking. I understand. I mean, these are very sensitive issues.
Exactly.
Very sensitive for both parties, and I really want to be fair and appreciate that. But it's, the time is going by for both parties, and you have the initial 4 years and then another 3 years. I mean, I'm just struggling with the time that's gone by.
Well, it's not like a party is going to be monitoring the statutory enactment of a frozen embryo situation. She just found out about it, and that's when I was contacted in the last 2 years.
Okay, fair enough.
So it's, the circumstances, whether or not she's following the law and waiting for this opportunity to arise, I think she enacted promptly when she did find out that statute did exist.
So I know you're asking us to interpret the statute and rule that the Superior Court wrongly interpreted it. But even to get there, then procedurally, you need us to find that you're entitled to Rule 85 relief under subsection 5 or 6. Is that correct?
That's the
that's
second
your
part of the
avenue to
argument.
get
The
there.
first part was just that was an unallocated asset and should have been distributed.
Okay.
So that would be the separate civil action that we brought under Dressler or Riniger.
So even if we disagree with your Rule 85 analysis that she's not entitled, we were to find that she's not entitled under Rule 85, you're saying that the petition for distribution or allocation of the asset is separate?
That's a separate civil action.
Sufficiently separate.
Yeah, to distribute unallocated assets.
And the analysis that we engage in under Rule 85 doesn't direct that analysis at all?
Well, I don't see where Rule 85 fits for an unallocated asset. It's not one of the 5 or 6 factors listed there, except maybe for substantial hardship under Part 6 on the reasons justifying relief. But it's not newly discovered evidence. It's not fraud. So I don't see any of the 85 rules applying until we got the amended decree, because now there's an order allocating that asset. So now we can make the 85 argument saying that it shouldn't be applied prospectively under 85B5, and else causes a substantial hardship under 85B6.
We understand, I can't quote I'm sure you can quote the statute, but for omitted asset, and I think this was also, there's an omitted asset statute, right, that addresses, and it was also in the property settlement agreement, that if anything is omitted, then that omitted piece of property, that asset, it becomes, the properties now own it as tenants in common.
That's correct, sir. That's 25-318D and also in the PSA,
So,
property settlement agreement.
so help me understand. So how does that impact the case here?
Because now we have a certain special asset that's covered by a particular statute, and the specific overrules the general.
In essence, you're seeking a partition action.
I guess you could call it that, yes, sir. But remember, both attorneys, both
But that
parties
only applies
argued.
to real property, of course, I believe. I mean,
Yes, but both parties agreed that 318D did not apply as far as giving 2 embryos to my client and 2 embryos to the father.
Does the parties' agreements, are they binding on it, on the court?
Well, not when it comes to subject matter jurisdiction, but the court had subject matter jurisdiction to distribute this asset. And because there's a particular statute that says it goes to the party that wants to bring the embryos to birth, it follows that they should have been awarded to my client because it deals specifically with this type of property. Suppose there was a retirement account that was left out of the decree. It's not automatically 50-50. You still have to calculate what the community interest is and then divide that proportionately. So it's not like it's an automatic rule 50-50. And again, neither party wanted that type of distribution.
Well, but that's where you're dealing with determining what's separate or community. If there was a retirement account that wasn't allocated, wouldn't it be presumably 50-50 to the community aspect?
The community aspect,
Yeah.
yes. But again, if it's simply a missing asset and it's worth $150,000, that doesn't mean it's automatically 50-50 under that joint tenant or tenants in common statute.
But the community share of it is.
Correct.
And in this part, there's no dispute that it's 100% community.
That's correct. But neither
I'm
party
just not
wanted,
following what your analogy.
it's just that neither
How that
party
works.
wanted a 50-50 split in this case. So again, we feel the statute would cover this issue. And as far as the non-proton, we covered that we believe that's the error was caused by the parties rather than the court, so it shouldn't have been non-proton. And then on the motion for relief, under Rule 6 or through Rule 85, the court should have applied the statute. The ruling that the judge made, the amended decree, applying the statute prospectively was inequitable because, again, the parties are at a stalemate. My client's been making all the payments on the storage fees. She has a definite connection with the embryos that she wants to bring them to birth. And continuing this agreement where they can't agree is totally inequitable because she wants to bring those children to birth. I've got about 4 minutes left, and I think I want to reserve my time for rebuttal, unless the court has any questions for me.
Thank you.
Thank you.
Good morning. May it please the court, my name is Michael Shue, Mr. Lombardo, and I represent the appellee Kenneth Hanzuk. I note that I'm hearing impaired. If I ask you to repeat a question, I don't mean any disrespect. There's no dispute that the parties entered into a contract more than 20 years ago. That contract required both parties to consent with respect to the use of these frozen embryos and how they would be disposed upon.
Counsel, is that contract from 20 years ago in the record?
Your Honor, it is attached.
Our record, I guess.
There's an unsigned copy of the contract that is attached to Mr. Hanzuk's affidavit that was filed along with the motion to dismiss. In reviewing the record, I didn't have the exhibits that were admitted in the 2014 proceedings. There's been no dispute from the appellant, though, that there is no contract or that the form of contract that was attached to the affidavit is not the same one that Judge Hicks had considered in the 2014 proceedings.
Okay.
So what's relevant is in 2014, Judge Hicks adjudicated this claim. The notion that appellant has raised that somehow we can ignore that these proceedings occurred and it is a legal fiction. Merely because that order was not incorporated in the consent decree doesn't mean that a judgment was not rendered. Judge Hicks rendered a judgment. A clerical error was made by the parties, not by counsel, not by the appellee, but by the parties in failing to include Judge Hicks' order in the final decree. Judge Hicks didn't sign the order. She didn't include Rule 78B language that would have allowed for the entry of a final judgment on that specific claim while reserving the other issues. Regardless, the appellant didn't take any action after that occurred. Judge Williams, in adjudicating the petition that the appellant filed last year, found that there was no evidence that the parties intended to omit that order. In other words, there's no evidence in the record that the parties had somehow agreed after Judge Hicks had entered her order in June of 2014 not to include that order because they reached some different agreement.
Say I agree with you, at least in part, that the issue had been resolved and the fact that it wasn't included in the decree isn't necessarily controlling. But what does Judge Hicks's original decision do? It doesn't really allocate it to anybody. It just leaves it in flux, doesn't it?
I didn't hear the last part, Your Honor.
I'm sorry. I'll try and speak up and get the mic instead of lounging back there. What does Judge Hicks's order do? It doesn't really allocate it. Even if I agree with you that her decision was issued and should have been incorporated into the decree, it doesn't allocate the embryos to anybody, does it?
Well, it does, Your Honor. This would not be, first of all, we obviously all recognize, I think, that this is a unique type of property. It's an interim type of property because of its potential to become human. But this would not be, if we put it to another example, like an interest in a limited liability company or ownership in real property, this wouldn't be the first case where a trial court had ordered the parties to continue to own an asset that was indisputably community property post-divorce and to work out whatever arrangement they needed to work out at some future date. They may own an interest in a home or in raw land or something like that, and the court could say, well, your interests are affirmed as tenants in common, and you'll have to figure that out in some other way, in some other form.
Yeah, but we see that all the time where then the parties can't dispute and they come back to the court and say, we tried and we can't reach an agreement on how to dispose of that, and so now we need you to decide for us and allocate this property. Why is this any different?
But to the extent that you're implying that there would be a partition action, you can't just simply say, well, there's 4 embryos, you get 2 and you get 2. Each party's...
Right, I'm saying, let's say it's not a partition action. This is a Rembrandt worth $100 million. And the court says, you guys own it right now jointly, and you guys need to figure out an agreement on how you're going to sell this or who you're going to sell it to and how you're going to divide the money.
Well,
and then, so that's the way the order is, and it's been not allocated, but you guys jointly own this and figure it out. And 2 years later, they come back and the parties say, my husband thinks we can sell it to this guy for $150, and I want to sell it to someone else for $75, whatever. The courts then decide those issues and allocate that money and figure out how to divide it. So why is this different?
Because there's a contract, and that contract requires both parties to consent with respect to the distribution of this property. And just because the appellate...
Wait, what's a contract?
The fertility contract that they signed when they agreed to store these embryos, they agreed long before they got divorced and long before 25-3-1803 went into effect that neither one of them could override the other one's opinion. And just because the appellant now claims there's a dispute 8 years later, Your Honor, that doesn't necessarily preclude them at some future point in time of agreeing on how to dispose of the embryos.
Counsel?
I mean dispose, but I mean to how they might be utilized. I apologize.
Do you have any cases you can point us to, sort of in this area that Judge Morse is exploring, telling us whether that initial ruling is an allocation? In other words, or is a distribution, that the court's decision at the time of the decree to grant the parties, joint ownership subject to future agreement of the parties or future distribution by the parties themselves, that initial decision constitutes a distribution or an allocation?
I cannot, off the top of my head, no, Your Honor. I cannot cite you to a specific case. What I would say to you, though, is we need to respect the finality of the judgment in that decree. And the respect for the finality of that judgment means if the appellant didn't appeal from that, didn't take any action and sat on her rights for all of these years, it she shouldn't ought to now be able to come back and complain about something that should have been dealt with years ago because of the prejudice that now might inure to the appellate.
That gets back to my question, and maybe I'm just being obtuse on this, but what is the finality in Judge Hicks' ruling? There is no finality in it.
The finality is you folks abide by your contract and you either reach an agreement or you don't. And that is
But
that
doesn't
is
that
the
essentially
judgment.
leave the embryos in limbo?
Well,
Not in the religious sense of the word, but
25318 does not require property to be equitably divided in kind. Okay, the judgment was made that you folks need to abide by the terms of your contract. You bargained for that long before.
all right. So, and I appreciate that. Different scenario, and I acknowledge this is not the situation we have, but let's say they had that contract they entered into back in 1990 something. When was it? 2001, sorry. And they just were getting divorced today. What would be the result?
ARS 2531803 would not apply. ARS 25318 is not, 03 is not, it does not expressly hold that it is to be applied retroactively. The Supreme Court in Terrell v. Torres already told us that that statute is not to be applied retroactively. The Arizona Constitution prohibits an impairment of a substantial contractual right. What does that mean in practice? That means that 2531803 from our side of the aisle should not apply to any fertility contract that was entered into prior to August 3rd of 2018 when 2531803 went into effect. What I think Judge Brown might be picking up on is all of the arguments that the appellant are making, while they claim we're not trying to retroactively apply this statute, all of these legal arguments are really intended to use the statute. And his argument itself here this morning basically implies that because 2531803 evidences some current public policy of the state of Arizona that frozen embryos should be awarded to the spouse that intends to develop them to birth, that that's what he thinks needs to control today, merely because appellant decided 3 years after the statute went into effect to assert rights that she didn't previously assert.
Let's assume, for argument, that I disagree, or that all of us were to disagree that Judge Hicks actually made an allocation, that she failed to do so. So what are your strongest arguments to still affirm Judge Williams' decision under that scenario?
Even if Judge Williams didn't actually allocate these frozen embryos.
You mean Judge Hicks, you mean?
Judge Hicks,
Yeah,
yes,
okay.
thank you. Judge Williams did. She made an independent determination based on the evidence that had been presented and the arguments that were provided by the parties at the proceedings in December of last year. So she didn't necessarily, Judge Williams did not have to correct this clerical error. She reviewed this de novo, essentially. She considered their argument that 2531803 went into effect. She considered the argument that Edsel allowed them to set aside or reopen this judgment because the prospective application of the decree is no longer in effect. And she made the decision, just like Judge Hicks did, that you folks have this contract, you need to figure this out on your own. It does not give, the circumstance that the parties are in right now does not give, frankly, either party de facto veto power. Well, I'll say it this way. It doesn't give the appellee de facto veto power over the appellant any more than it gives the appellant de facto veto power over the appellee's desire to donate the embryos to a suitable donee or couple who might be in a better position to develop these children to birth, potential children to birth, and to raise them and to take care of them. So I want to spend a few minutes and talk about the relief that the appellant has requested. What the appellant has asked the court to do is basically determined as a matter of law to vacate Judge Williams' order denying the motion to set aside, to vacate Judge Williams' order that denying the petition to distribute the unallocated property, and for you folks to remand this entire proceeding with instructions to award all four of the frozen embryos to the appellant. That is a step too far. That is relief that was similar to the relief that had been granted in the Court of Appeals in Torres v. Terrell. Judge Cruz, in her dissent, pointed out that the Court of Appeals can't just simply supplant the trial court's fact-finding role and just award these embryos to someone that claims that they want them. Now, with respect to the statute that's in effect, there's a factual dispute. Judge Williams didn't hear sufficient evidence. The record isn't sufficiently developed. That evidentiary hearing in December of last year was a hybrid of oral argument, mostly oral argument, very little cross-examination, very little evidence with respect to the issue that if 25318 does apply, that the appellant is the party that is more likely or is the party that intends to develop the embryos to birth. So this court should not just vacate with instructions to award all four of the embryos. And if I may jump backwards just a second with respect to the embryo statute itself and the interplay between 25318D and 318A. 318.03 repeatedly, 16 times, uses the word spouse. Doesn't use the word ex-spouse, doesn't use the word donor, doesn't use the word party, it uses the word spouse. That statute was intended to be applied in original dissolution of marriage proceedings that arise under ARS Section 25318A. The effect of 25318D, is that upon the entry of that the parties' divorce decree in 2014, they own these embryos as tenants in common. The trial court doesn't have jurisdiction over the parties' separate property. The parties' property settlement agreement itself, they agreed on a contractual basis in their property settlement agreement that they would own omitted property as tenants in common. And an appellant just elides that contractual agreement itself and just says, yeah, well, 25318.03 applies now. I know I jumped around a little bit, but with respect to the relief that is requested by the appellant, even if this court agrees with the appellant on one or more of the bases that they have asserted why they're entitled to relief, and this court vacates the judgment, it must remand with instructions to hold an evidentiary hearing and take proper testimony and consider the evidence. The judge essentially ruled as a matter of law on the parties' briefs and their motions and the petition based on a minute of testimony from the appellant and a few minutes of examination of the appellee. That is not a sufficient record, in our opinion, for you to make a decision as a matter of law that the appellant is the spouse, putting aside that they're not married, who intends to develop these embryos to birth. Thank you very much. I appreciate it.
Thank you, counsel.
May it please the court, Stanley David Murray again for the appellant. Mr. Hsu told the court that the contract provided that the parties had to agree, but if you look at Judge Hick's ruling, she found that the contract did not apply in this situation of a dissolution as to what to do with the embryos. So the contract does not apply in this situation.
I think she just said the contract didn't address what happens if there's a dissolution. I don't think the court recognized that they were bound by what they had agreed to.
I don't recall any specific finding by Judge Hicks in that regard, Your Honor.
I thought there was a line that said, as the parties have agreed, that neither one can do anything with the embryo. Well, don't you agree? You don't dispute that there's a contract in the record. It's not signed, but I didn't see anything in the record where you disputed that was the party's agreement with the center.
That's true, Your Honor. The agreement that was submitted wasn't signed or initialed, but I
That
can't
is
say
the-
that that's not
There's
one
nothing-
that the judge considered.
There's no reason you have to believe that one of the parties can walk into the center and take the embryos.
That's true. We need a court
Okay.
order to do that, to protect the fertility clinic especially. In regard to your question about my client not taking action when Judge Hicks made a ruling, recall the language that Judge Hicks used in that order. She told my client, go ahead and make those storage fee payments because there might be an agreement later, giving her a false sense of hope that maybe the parties could work things out. So I think that might be her reasoning for not appealing or trying to special action that original order.
But if I recall the record correctly, I mean, your client indicated that she might just pay the fees indefinitely because she was concerned about it, and she didn't know if she would ever want to use them, but she might just go ahead and and pay indefinitely.
Well, she knew she had to pay the fees because husband wasn't paying the fees, and she was paying those fees in the hopes, as Judge Hicks mentioned, of a potential agreement to be reached at a later time.
My recollection was that she said at the time that she didn't know if she would ever want to develop the children to birth, or the embryos to birth.
Oh, I wasn't aware of that, if that's what the record shows. But the fact that the statute now exists gives her the impetus to request the award of those embryos. And again, let's assume that Judge Williams' ruling amending the decree is correct. That's when the Rule 85 argument comes into play.
So your opponent there cited Terrell and I kind of thought I agreed with his reading, but you seem to say disagreed. Do you think it applies, that the statute applies to the contract that you guys entered into in 2002?
No, I think the statute abrogated it. Even though that contract existed beforehand, the statute clearly says, regardless of what a contract says, this is how the embryos are to be divided.
But didn't Terrell say otherwise, say that it doesn't apply retroactively?
The distribution or the requirements of how the parties should have to agree doesn't apply to a prior action, but for any actions afterwards that involve an older contract, I
So
think
the
that statute
retroactivity in
does.
your mind is determined at the time of the distribution, so it would matter.
Time of
under the
dissolution.
hypothetical I was posing, a couple that had signed that contract in 2002 but got divorced in 2020
Correct.
would be subject to the statute, but a couple that got divorced in 2017 wouldn't.
That's right. You know, I represented the mother in the Terrell versus Torres case, and I was considering the retroactive application of that statute. And it seemed to me that because the action occurred at a different time than when the agreement was entered into, that I couldn't use that statute unless the divorce happened after the statute.
Thank you, counsel. Your time has run.
Thank you.
We appreciate your arguments. We'll consider the case submitted and issue our decision in due course, and we will recess to reset for the next argument.